So hi everyone. So today we are going to start with the concept called as liquidation under insolvency and bankruptcy code. So the liquidation concept will be the last area to the insolvency and bankruptcy code. PPIRP, all those things are already completed. So the last area for insolvency code will be the basics of liquidation and the liquidation process. So some sections are there, important sections, around 10 sections are there. So once we complete those 10 sections, the main liquidation area under IBC will be completed. So let's see the liquidation concept, how it actually works in insolvency and bankruptcy code. Okay, so let's make a deal. So liquidation process. So let's see the screen. First one, basics of liquidation. So in basics of liquidation, as you already see on the screen, first page will contain 33, 34 and 35. So let us see what it is. First, initiate process of liquidation. When the liquidation process will start, first the grounds. Three situations may come which may call for the liquidation under insolvency and bankruptcy code. There will be three different situations or three different grounds under which under insolvency and bankruptcy code liquidation can take place. What are the three grounds? Let's see. First, AA before expiry of CIRP. I repeat, AA before expiry of CIRP. CIRP will take 180 days. Extension may go beyond 180 days. So before expiry of CIRP or extension given does not receive any resolution. Which resolution? Resolution means resolution plan. That means within that 180 days period, they didn't receive any kind of resolution plan. This is under normal CIRP going into liquidation. Company is following a fast track CIRP. Okay, so even the same concept. AA before expiry of 50 CIRP under section 56 does not receive any resolution plan, or it received, but AA rejects the resolution plan due to non-compliance. In these cases, the effects of non-compliance or any of these three, first they will pass an order of liquidation. How public announcement will be given when a company is subjected to CIRP? In the same way, another public announcement will be given whenever a company is subjected to liquidation. So first order of liquidation will be passed, public announcement will be given that the company is going into liquidation, and order liquidation shall be sent to, the order of liquidation shall be sent to authority with which the corporate debtor is registered. Example, corporate debtor can be of two types. Number one, it can be company, it can be LLP. If it is company, to the ROC of the concerned state, LLP, ROC of the concerned state, because LLP and company both are governed by MCA through ROCs. So the concerned ROC will be sent a notice that this company under your jurisdiction is now subjected to liquidation. Okay, so first one, what are the grounds of liquidation? Number one, time limit of 180 days or such extended time is completed, but still we didn't receive any kind of resolution plan, or for FTCARP timing is completed but we still didn't receive any resolution plan. Okay, or received within the time limit but the AA has rejected the resolution plan. Okay, in these cases, first order a liquidation process, issue public announcement, and liquidation details will be, order of liquidation will be sent to the concerned ROC. Now, what is the power of resolution professional? Power to liquidate. RP during CIRP but before confirmation of resolution plan. Okay, RP during CIRP but before confirmation of resolution plan intimates AA the decision of COC by vote of not less than 66% to liquidate corporate debtor. Means the resolution professional intimates, okay, the resolution professional intimates. When it intimates, even before resolution plan is approved. If you observe clearly, here the ground is resolution plan is not yet submitted. Resolution plan not yet submitted. Resolution plan submitted but rejected. As a resolution plan not at all prepared, even in that case we can liquidate an entity provided COC with the decision of 66% has asked for a liquidation process. So now, so the summary is CIRP process is going on. Resolution plan not yet prepared. That much stage also not yet received, not yet reached. But The committee of creditors has passed a resolution with 66% majority requesting to liquidate. Sir, then COC will obviously ask, sir, always they will try to liquidate the entity. Just because creditors say liquidate, company will be liquidated. You are not understanding the impact of liquidation. Liquidation is not a boon, it's a bane. Okay, technically to understand, if you are going under CIRP, distribution of the assets will be made only to the defaulted creditors. If there are 100 creditors in the company, 10 creditors are defaulted, 90 are not defaulted. Only to those 10 we will take care in CIRP, not to all the other creditors. Unnecessarily, why we will pay to others? So when the company going to liquidation, the problem is a waterfall approach will start. Means what? All creditors will be given a equitable importance. Means what? First payment will be made to workmen, like that it will start. In a waterfall approach they will come step by step they will make the payment. Okay. So try to understand clearly. Liquidation la headache. Liquidation la along with the defaulted non-defaulted creditors also will get the realization. But in CIRP only defaulted creditors will get the realization. There is a lot of difference. Payment to 10, payment to 100. There is a lot of difference. So therefore unnecessarily committee of creditors will not liquidate entity. They don't want to liquidate. Am I clear? Sir, for example, a person has taken loan from us. A person has taken a loan from us. He is not paying. Now we will give two options to you. You only choose and tell me. Okay. We will pray the God. God, please give him some wealth such that he will pay to us. Like that you will think, or God, kill him. Array, if you kill him, that 1 rupee also you will not get. Same thing happens also in a company. You are thinking that liquidation means happily creditors will liquidate. Creditors, when they start liquidating the entity, it's not a boon. Rather, it's a bane against them. So it's like a punishment to the creditors. But there is no last resort. There is no chance. CIRP started first 2025 days itself. We understood that this company is a big dormant company. Therefore, directly creditors said that anyway, this company will go into liquidation even after 180 days. So let us liquidate today itself. At least the time value of money will be saved. So therefore, the point is, the resolution professional will intimate the adjudicating authority about the decision of the committee of creditors to liquidate the entity, such they pass the resolution in the committee with 66% voting share. So they will inform. Now the adjudicating authority will liquidate. So ground number 1, these are the first 3 grounds. This is a ground where creditors ask. There is a third very important ground of liquidation where due to non-compliance company goes into liquidation. What is that? Let's see. This is the arrow mark. Where resolution plan approved by AA. First, resolution plan is prepared by resolution applicant. That resolution applicant approved resolution plan has went up for, I repeat, the resolution plan approved by the resolution plan prepared by the resolution applicant will go for COC approval. COC approved. Thereafter it goes to AA. AA also approved. That approved resolution plan has to now put into implementation, but they contravene during implementation stage. Okay. Any person other than CD whose interests are prejudicially affected, creditors, some workmen, employees, government, some person who is affected by that non-compliance may apply to AA for liquidation, and AA shall pass an order for liquidation if it is satisfied. Okay, these are the various grounds of liquidation. Now, appointment of liquidator. Sir, to liquidate an entity, who is required? Liquidator is required. So, liquidator will be appointed. Whenever AA passes an order for liquidation, RP who is under CIRP will become liquidator provided he give the written consent. Okay, and he will take over the entire management again. The board of directors KMP powers will be transferred to the liquidator. So if AA passes an order for liquidation, RP appointed for CIRP shall act as a liquidator provided he give the written consent. Okay, next one. Powers and duties of liquidator are a same question. First he will verify the claims of creditors. Okay, all the assets will be taken into his custody because he has to sell those. So take into his custody or control all the assets, properties, actionable claims, etc. Okay, next one. I need to know what are all the assets belonging to the corporator because I have to sell them. To take such measures to protect and preserve the assets and properties of the corporator. To carry on the business till it goes into liquidation. To carry on the business till it goes into liquidation. These are all the various powers and duties of liquidator. These powers are same as resolution professional. Just for the place resolution professional, we have to replace with the liquidator. He also do the same thing, verifying the claims, controlling. He will take the custody of all the properties, assets, and actionable claims. He will evaluate the value of the particular assets, take measures to protect those assets, and carry on the business till the company goes on will be beneficial liquidation. Next issue. Important, sir. Liquidation estate. Liquidation estate. So, liquidation estate. Estate means what? Estate means a group of assets is called as a estate. Estate means a group of assets. Okay. Now let us understand what is this concept of liquidation estate. Liquidation estate is a group of assets. Liquidation estate is what's a group of assets. Okay. Let us try to understand what is the relevance of liquidation estate. To pay the liabilities at the time of liquidation, assets should be there. Which asset should be taken is called as a liquidation estate. Assets forming the liquidation estate will be used to pay the liabilities. Okay, basics. Liquidator shall form a liquidation estate and shall hold liquidation estate as a fiduciary for the benefit of creditors. That means the estate will be used for ethical purpose of payment to the creditors. Okay, what are included, what are excluded from the liquidation estate? Let us see now. What are included? What are all included? Included into what? What are all included into the liquidation estate? Let us see. Any asset, okay. Any asset over which corporate debtor is having ownership. Okay. Any asset may or may not be in the possession of CD. That means ownership is required. Possession may be there with another person, no issue. Okay, asset belongs to me, but I kept as a security with the bank. That is also my asset. Next one. It can be tangible or intangible. It can be tangible or intangible. It can be tangible. Okay, it can be intangible. I read both of these. Okay. Intangible includes various things. Intellectual properties, insurance policies, securities, contractual rights, many things. Licenses, etc. will be there. Na? All those. Next. Assets subject to determination of ownership by court or authority. As of now, property belongs to me. Some person made a dispute. Okay, dispute is still pending in the court. Till it is not decided that the property belongs to him. Therefore, as of now, it is my property. Na? Those also we will take. Any assets or their value recovered through proceedings for avoidance of transaction. Meaning I will discuss later. This you keep in mind. Avoidance transactions we are going to read next. Okay, at that time when I discuss this don't require any other explanation again. You will understand. Any asset of corporate debtor in respect of which secured creditor has relinquished the security interest. Okay, sir, what is this? This point also we will read again, but I will explain here. Any asset of corporate debtor. So there is a corporate debtor. A asset belongs to that corporate debtor. Okay, in respect of which secured creditor has relinquished security interest. Sir, what is this concept? Listen now. I am a secured creditor. What do you mean by secured creditor? Secured creditor means an asset will be there on which there will be a security. That means whenever a creditor gives amount to the company, that person will ask for a security or not. That security is an asset. That asset is called as a security interest. That asset is called as what's a security interest. At the time of liquidation, how the secured creditors will be paid? That concerned asset will be sold, amount will come, I will pay to that secured creditor. This is a general tendency. But sometimes what they will tell, okay, they will tell that, okay, I will do one thing. That asset is there, which you will sell. It may get a lower value. Do one thing, convert secured creditors into unsecured creditors. Because of that, what will happen? I will not sell that asset and get the money. I will sell entire companies, all the assets and get the cash. That cash will be used to make the payment. That means that one particular asset is not apportionable to my payment. Okay, that one particular asset you will not use for me. Like a unsecured creditor, you treat me. Means what? Sell the assets, pay to workmen, pay to employees, pay to important persons first. Later cash will be available. Like an unsecured creditor, pay to me. Because that asset if you sell, my loan amount due is 100 crore. Asset if you sell, I will get only 35 crore. Instead of claiming that 35 crore asset and getting back 35, I will do one thing. I will ask you to treat me as a secured unsecured creditor. What will happen now? That asset is no more apportionable to that secured creditor. It will be free from all the charges. Those assets also will be taken. those assets will not be apportioned to that secured creditor. It will be forming part of liquidation estate, belongs to everyone. Next, any other party, any other property belonging or vested to the corporate debtor at the insolvency commencement date. Other than this, any asset is there. Okay. Next, whenever realization is made, that means all proceedings of liquidation as and when they are realized, means what? Not only the assets are sold in the market, cash received, that also will form part of liquidation estate. If you tell that cash realized out of the sale of properties is not a liquidation estate, they will misuse again. Therefore, all proceeds of liquidation as and when they are realized will also be called as a liquidation estate. All these will be included into estate. But what are excluded? Let's see what are excluded. Assets owned by third party which are in the possession of corporate debtor. That we need to remember. For those, these are examples. Examples are 1 or 2 examples you need to remember. I will also explain what those are. Assets held in trust for a third party. Assets held in trust for a third party. Okay. So first we need to understand what is this assets held by a trust. I already told you in the normal session so many times, but still some people who are listening to these classes might not have this clarity. Therefore, it is imperative for me to explain. See here. First, trust means what? We need to understand. See here. Trust is basically an obligation. Obligation to provide benefits. Providing benefits to whom? Specified persons. These specified persons are called as beneficiaries. Who will create the trust? Author will create a trust. Cast obligation on trustee. Trustee will be the discharger of obligation. Discharger of this obligation. See here. Trust is basically an obligation to provide benefits, providing benefits to specified persons. These specified persons are called as beneficiaries. So, trust is basically an obligation to provide the benefits, providing benefits to specified persons. These specified persons will be called as beneficiaries. That means, trust will be created. Means, one person will be there. To create anything, one creator is required. Trust will be created by a person called as a author. Author will create the trust. Okay. For example, I will give a general example. Same we will apply also with the company. One person is there, grandfather, almost he is in deathbed. He has huge properties in Hyderabad. What he will do, he will call grandson and tell, we have so many properties. Okay. Use that properties after my demise. I am writing in your name, but not in your original name. I am writing you as a trustee. What you have to do? All the properties that belongs to me, okay, I will be transferring it to you. Okay, I will be transferring it to you. What I will do? I will irrevocably transfer my properties to you in your name. These properties are called as property held under trust. From this property, income will be generated, which will be called as income derived from property held under trust. Okay, this income trustee will utilize for the benefit of beneficiaries. Okay, so author will cast obligation on trustee. Okay, So trust is an obligation to provide benefits to special persons called as beneficiaries. Who will create the trust? Author will create the trust and cast obligation to provide the benefits on a trustee. Trustee will discharge the obligations. That means trustee has its own properties, author transferred properties, author transferred properties, and the trustee will hold in its own capacity, in a trustee capacity, in a trustee capacity. Therefore, asset does not belong to me, but some other person's assets by belief, faithfulness, trustworthiness, they have transferred to me. I should not misuse that. Therefore, law also tells the same. Now let us see. Author is there. Who is there, sir? Some author. Some author is there. This trustee happens to be X Limited. This X Limited is the corporate debtor. Corporate debtor will hold some properties. In which capacity? Trustee capacity. As a trustee, it is my asset, it is not my asset. Therefore, assets held in trust for a third party. For an author is a third party now. Those assets really belong to them. For the purpose of ensuring to give some benefits, I became a trustee. But asset does not belong to me. Representative capacity I am holding. Representative SSC concept is a section 160 subsection 1 clause number 5 income tax. How to make the taxation for the representative SSCs is dealt there. You can read that section 160. So assets held in trust for a third party. Next one, bailment contracts. Which contracts are? Bailment contracts. Sir, what is this bailment contract? Bailment contract, there will be two parties, bail or bailey. Bail or bailey. Bailment contract, first essentially is there must be movable goods. Movable goods are transferred from one person to another person. This person who is transferring is called as a bailor. Person to whom it is transferred is a bailey. Okay. For example, company is a person involved in a job work. They will do some painting work and send back the goods to the main manufacturer. Okay. A machinery came to the company on a bailment work. Bailment work means I will be transferring asset from one person to another person for a purpose. Once the purpose is accomplished, he has to give back the goods. Okay, that's a bailment contract dealt in bailment and pledge contracts in Contract Act. Now company is a bailey. Means what? Company is a entity involved in job work. Paint work it will do. Some company will do the manufacturing. Painting work will be done in our company. Asset came to me for a painting work. Asset belonged to me. It came for some bailment work. Once it is complete, I will give it back. Therefore, on a bailment, if some assets are held by you, those will not be taken. Likewise, employee contribution towards the provident fund, pension fund, etc., any other contractual obligations, all these things are assets owned by a third party. Those should not be included into the liquidation estate. Next one, asset in security collateral held by financial service providers and are subjected to netting off and set off of multilateral trading or clearing transactions. You have taken loan from a person and you are taking a loan from a person. You have to repay them. We said that I could not repay you. Take this asset and net off that particular amount. Okay, those assets. Already it has been done. Okay, before even liquidation start, already the netting of transaction has been made in that case. Okay, next. This is all about avoidance transaction. Again, I said avoidance transaction we have to read. Assets of any Indian or foreign subsidiary of corporate debtor. Only that company's assets you should take, not the subsidiaries. Okay, any other assets as decided by the IBBI, all these will be excluded. So this is one important question. The concept is called as a liquidation estate. Okay, now next issue, claims and connected issues. Okay, what is the concept of claims and connected issues? 38, 39, 40, 41, 42. How many sections are there? 5 sections will be there. Consolidation of claims. Let's see. Duty of liquidator. Liquidator shall receive or collect claims of the creditors within how many days? 30 days from the date of commencement of liquidation process. Okay, let us see what it is. How claims will be made at the time of CARP. Same time claims also will be made during liquidation. Okay, collect all the claims. Duty of liquidator shall receive or collect claims of all creditors within 30 days from the date of commencement of liquidation process. Wordings you need to observe. CARP is carried on. CARP there is a concept of financial creditor, operational creditor, all those. When liquidation is started, no bifurcation is given. Directly use the word creditors. I should receive claims from all the creditors. In the case of CARP, 100 creditors are there. In that only 10 creditors are defaulted. And those defaulted creditors, we call them operational financial. But here at the time of liquidation, there is no bifurcation. Every creditor will be paid. Therefore, I use the word creditors. Okay. I use the word creditors. There may be partly financial, there may be partly operational. You can use the word operational financial even here, but there is no relevance even if you use. So duty of liquidator. Liquidator shall receive or collect claims of creditors within how many days? 30 days from the commencement of liquidation process. Rights of creditors. In that now we will see. Right of financial creditor. Submit the claims in the following manner. They can submit through the IU. IU means information utility, or any other supporting documents. Right of OC, only supporting documents to prove their claim. Separately in IU it is impossible. Joint status, I am both FC as well as OC, then he will comply with the requirements of this and this. Next issue, verification of claim. You made a claim, but maybe some false claims also may be made. Therefore, I need to see really you are a creditor, really you are not yet received the payment or not, I need to check. The liquidator shall verify the claim submitted within such period as determined by the board. Power of liquidator. The liquidator may require any creditor or corporate debtor or any other person as he thinks necessary, okay, any other document or evidence which he thinks necessary for the purpose of verifying the whole or part of the claim. Simply, other than IU and other than these documents, I may also ask for some additional evidence to check whether you are a real legitimate claim person or not. Okay. Next issue, admission or rejection of claims. The liquidator shall communicate his decision of admission or rejection of claims to the creditor and the corporate debtor within 7 days. That means whether you are making a correct claim or wrong claim. Means claim also have one important point here. It should be within the period of limitation of 3 years. If it is outside that purview, even though it is a truthful claim, it will be barred by the limitation. So whether I am accepting your claim or not, within 7 days he has to make the communication. Power of liquidator. The liquidator may, after verification of claims under section number 39, either admit or reject the claim. Next, determination of valuation of claim. Determination of valuation of claim. The liquidator shall determine the value of claims admitted under section 40 in such manner as may be specified by the board. Means what? All the claims will be there. I will total everything and I will value those particular claims. That means 100 rupee loan was given by me. In that 50 rupees was given 5 years back or 10 years back. 50 rupees was given recently. Both are defaulted. One is outside the limitation period, one is within the limitation period. I should take only 150 which is within the limitation. Therefore, I have to value totally, okay, all the claims which are legitimate. Okay, that will be called as a determination of valuation of claims. Appeal against the decision of liquidator. A creditor may appeal to the adjudicating authority against the decision of liquidator, okay, accepting or rejecting the claims within a period of 14 days. If he rejected, within 14 days you can go for a appeal to the adjudicating authority. Just take a minute time and read this properly. These are all small sections. Chance in examination are low, but there in the syllabus now we need to give one reading. Read it once. So hope you have completed. So now let us go into the next part of the discussion with regard to this liquidation process. Okay, see here, next issue, adverse transactions and its impact. Now we will see all these avoidance transaction, all these things will come. Okay, avoidance transaction, preferential transaction, exorbitant transactions, all these concepts will come. So these are the areas, extortionate credits, all these things will come. Remaining FTC, ERP, small concepts only, mainly liquidation portion we are going to concentrate. So anyway, let us see adverse transactions and its impact. Sir, what are these adverse transactions? First let me explain the modus operandi. Whenever the liquidation is going on, okay, whenever the company is going into the process of a liquidation, assets will be totaled, liabilities will be discharged. Okay, point is, some valuable assets of the company, okay, will be repaid back or will be transferred to some creditors by giving them a unintentional or intentional higher preference than others. Sir, I didn't understand. Sir, anyway, I will explain like this. There is a creditor who has to get the repayment in 2020-22, but by selling an asset they will repay it in advance. Why you repaid it? Maybe you have a bad intention in mind. What is that bad intention? That creditor is my related party. We already came to know, board of directors, we already came to know that, okay, board of directors already came to know that this company will definitely go into liquidation. When it goes into liquidation, our related party being a creditor will also be subjected to liquidation process. At that time, he will not get entire value, assets will be sold and he will only get a partial value, which they don't want to do. Therefore, they will give a fraudulent preference to him. Okay, therefore, the date on which the liquidation will commence, okay, from there, I will not take anything. I will take insolvency commencement date as a base. Insolvency commencement date means the beginning date, not liquidation commencement date. Insolvency commencement date I will take. Insolvency commencement date is a date on which the application has been admitted by the tribunal. Okay, from that date go back 2 years. In any of those 2 years, if any creditor is given any unnecessary importance or any transaction is made with him, those kind of creditors and those kind of transactions are called as adverse transactions. Okay, adverse transactions. Sir, what is this adverse transaction? Everything I will explain. I repeat once again. Company will be giving a fraudulent preference. Means what? You are giving more importance to one creditor than others. That kind of preference you are giving to others instead of giving a basic preference, we call it a concept of a fraudulent preference. Okay, so whenever there is a fraudulent preference, a creditor will be paid before the due date and he will be given more importance. Law will ask 2 questions. Why you have done that? Is he your related party? Yes, he is a related party. Then one situation, no sir, he is not a related party, but I have given a preference to him. In that case, second concept will apply. So anyway, these are called as adverse transactions, also called as avoidance of preferential transaction. Preferential transactions are those transactions where one creditor will be given more importance than other creditors in the set. If that other creditor also comes in line with all the other creditors, he would have got a lesser value than what he has already got. Okay, those kind of transactions are called as a fraudulent preference. That will be one area. Similar concepts are also there in exorbitant credit transactions, etc., extortionate credits. All these 5 concepts, whatever we are going to read now, 4-5 concepts, are 90% similar to each other. Concept will be same. Okay, asset will be sent to one of the person in a fraudulent way. That will be the fraudulent preference and other related issues. So let's anyway see that first. So let us read the provision. Preferential transactions and relevant time. Sir, what is the relevant time? Relevant time means 10 years back I gave preference. That will also be considered now. So what is the relevant time to take what is preferential transaction? That's what they want to tell. See here. Application for avoidance of preferential transaction. Application to whom? AA. By whom? Liquidator or RP. RP can make during CARP, liquidator will make during liquidation. Okay, that means this application can be made even during CARP, not just at the time of liquidation. If CD has at a relevant time given a fraudulent preference, that means a preference given to one creditor beyond others, if at all this creditor would not been paid at that time, and if paid along with other creditors, he would have got a lesser value. So we are giving some higher preference to them. Okay, now what is the relevant time? Persons covered. If that particular person being a corporate creditor who is a related party, we will go 2 years prior to the insolvency commencement date. If a non-related party was paid 1 year preceding the date of insolvency commencement date, we will go. Okay, next. So inclusions and exclusions into fraudulent preference. What are included into fraudulent preference? Transfer of property of corporate debtor for the benefit of creditor. Not only the creditor, either for the surety or guarantor or any other liability of a corporate debtor. Transfer as above, which has effect of, okay, you made a transfer of asset, okay, to a creditor, surety or a guarantor, whoever the case may be. Because of making such a transfer of assets to him, it has a effect of putting such creditor or surety or guarantor in a beneficial position than it would have been under section 53. 53 section says a waterfall approach. Under that approach, if that person would have been paid, he would have paid a lesser amount. But now he is giving a benefit. he's been giving a benefit by putting him in a beneficial position by giving him a fraudulent preference. Next, exclusions. Transfer made in ordinary course of business. Ordinarily assets are transferred, no issue. Any transfer creating security interest in the property of corporate debtor to the extent that such a security interest secures, okay, new value and was given at the time of or after signing the security agreement that contains a description of such property as security interest and was used by corporate debtor to acquire such property, and such a transfer is registered with an information utility on or before 30 days after the corporate debtor receives the possession of such property. So what is this? Read that sentence once. Completed reading? Listen. Sir, first one what we read, fraudulent preference means you are transferring the assets of the company to a creditor instead of making the payment. Okay, you transferred equal amount of asset to them. That we call as a fraudulent preference, no doubt. If he is a related party, we go back 2 years. All related parties who have been transferred with the assets of the company, we will get back those recovery. If it is non-related party, 1 year. Instead of making the payment, why you are transferring the assets? So if that asset would have been there today, it would have got a higher value, because of which that asset is not there in the company. So the point and the problem is, asset value reduces means just to you only has to eat. Then what about other creditors in the company? So fraudulent preference is invalid. It becomes void ab initio. We will get back the recovery. Sorry. Now the problem is, even though you transfer the assets of the corporate debtor to a creditor, that will not be a fraudulent preference if any of these two conditions are existed. Transfer is made in ordinary course of business. Normally asset is transferred and we will take back again. Or second one is very important for the exam. I have transferred an asset to a creditor, no doubt, but not for the payment which we have already taken the loan. I repeat, asset of the company, corporate debtor, is transferred to a creditor. For what we are transferring? Not to repay the existing debt, for taking a new value of loan. For that we are putting a security interest. In that way, if you transfer the asset, no problem, because I have taken 100 rupee from a creditor. Along with interest, I need to pay 120. I am defaulted. For that 120, I am not transferring this asset. He is giving extra loan to me. Let's say 120 plus, already 120 is there. Again, I requested, please give me another chance. I will take another loan. I took 60 crores loan again. For that 60 crores, I transferred asset to him as a security, because this security interest transfer, creating a security interest in the property of corporate debtor, to the extent that, to what extent it is excluded? Such a security interest secures new value. Okay, security agreement was drafted, and that security agreement is also filed with information utility within 30 days. That means everything is happening legally. I am not repaying the older debt with this transfer of asset. I am taking a new loan for which I am creating it. That new value, whatever you created, no problem, sir. It will be registered with the information utility. That amount will not be called as a fraudulent preference. That's a genuine transaction only. Okay, that's all. Next issue. Provisions relating to undervalued transactions. So 45 to 47. 45, 46, 47. Okay. Undervalued transaction. After that, transaction defrauding the, it's not creation, it's a creditors by mistake. And extortionate credit transaction. So anyway, let us see this. So these are 5 sections. Once we complete, the main areas of liquidation will be over. See here. Avoidance of undervalued transaction. Okay. Sir, what is this undervalued transaction? Are a classic example, gift like that you have transferred assets. Are a transfer of assets, say problem means company is undergoing liquidation process, it is in a bad financial position, you are transferring assets as a gift. A overaction, like that act is asking. That's called as a undervalued transactions. Which transactions are said as UV, undervalued? Where corporate debtor makes a gift. For eating food he don't have, now he is making charity of food. So for eating for self, it don't have a plate meals, but it is giving donation of full meals. This is the overaction corporate debtors are doing. So which transactions are said to be undervalued? Where corporate debtor makes a gift, or a transaction which involves a transfer of assets by corporate debtor for a consideration which is significantly less than the value of its acquisition. Almost it is concessional consideration is there, either totally given as a gift, or a transaction which involves a transfer of assets by CD for a consideration significantly lesser than the value of acquisition, and the transaction is not in ordinary course of business. Normally, intentionally, for one asset to be taken, I have given another asset, like barter system. Okay, asset transferred for another asset. Okay, asset I acquired is 1 crore, asset I transferred is 5 crores. Significantly the value is less. Those we call as undervalued transaction. What happens if you do that? If that asset would be there, 4 excess crores may be realized. Those declare such transactions as void and reverse the transaction. Power with AA after an examination and upon application by liquidator or RP. Next, relevant period for unavoidable transaction. Okay, so under section 45, liquidator shall prove that if such transaction is with a related party 2 years, in all other cases 1 year, go back and void all the transactions. Application by creditors in case of undervalued transaction. Okay, where an undervalued transaction has taken place but liquidator has not reported, if those 2 people are silent, then creditor or a partner, whatever the case may be, shall make an application to the AA to reverse the transaction. So it will pass an order as such. That's a simple answer. Next, miscellaneous transactions defrauding the creditors. When section gets attracted, see here, where corporate debtor has entered into undervalued transactions as said in section 45, and AA is satisfied that those transactions were deliberately, intentionally entered for keeping assets of corporate debtor beyond reach of any claimant, or to adversely affect the interest of the claimant. That means I will transfer them to my relatives for as a gift, such that benefit should not go to the other creditors, or to adversely affect the interest of the claimants of the legitimate interest. Okay, in such case, you are trying to defraud the creditors or not, intention bad. Therefore, it will restore the position as it is existed before and protect the interests of the victims. Next, extortionate credit transaction. Okay, what is this, sir? Extortionate credit transaction. When section gets attracted, corporate debtor has been a party to extortionate credit transaction, and it involves receipt of financial debt or operational debt during 2 years preceding to the insolvency commencement date. Sir, what does it mean? A loan is taken by the corporate debtor. It is a reverse to all these previous transactions. Corporate debtor has taken a loan from X Limited. Ours is Y Limited, corporate debtor, taking loan from X Limited. What are the terms and conditions? You will take 20 crore loan, interest at the rate of 30%. They intentionally want to give that person a benefit. Which person? The creditor. Okay. Therefore, the lawmaker has said that if you intentionally taking financial debt or operational debt, though there is no requirement, even if there is a requirement, you are intentionally accepting the exorbitant means it is beyond the orbit. Okay, it is going beyond the sky limit. Unnecessarily you are paying excess interest when there is availability of credit at 14%. Why you are taking a loan at 30%? That means that 18% you want to provide benefit to that person. Those we call as extortionate credit transactions. That creditor will not be paid 30%. We will excess whatever is there. We will be avoiding those transactions. Extortionate credit transaction. Okay. A corporate debtor has been a party to extortionate credit transaction, and it involves receipt of financial debt or an operational debt. 2 years before we will go. Upon application by liquidator or resolution professional, AA may apply to avoid such a transaction. Okay, if the payment require exorbitant payments. That's all. So summarize everything. Okay, from where? Yes, from here. First point, preferential transactions and relevant time. Preferential transactions are those transactions where we are giving a fraudulent preference to any creditor. If he is a related party, go back 2 years before insolvency commencement, or in all other cases 1 year. Okay, so which will be included into that? Any transfer of property for the benefit of any creditor, surety, guarantor, or any other person being a creditor. That particular benefit, whatever you are giving because of the transfer, will be higher than what he would have realized if he get realization with all the other creditors. But in that, ordinary course transfer will not be taken, or a transfer of asset is made as a security for the loan already taken, a new loan taken, a new value of loan taken, then no problem. Next issue, provisions relating to undervalued transaction, section 45 to section number 47. Avoidance of undervalued transaction. Undervalued transaction means if you try to give a gift or to transfer any assets to another person at a value lesser than their acquisition cost other than in ordinary course, we will call it undervalued transaction. Undervalued transaction, how many years you need to go? If it is related party, same 2 years, other than related party, 1 year. Next, application by the creditors. If ROC or official liquidator, if RP or official liquidator is not taking care of these undervalued transaction, creditor themselves can make an application to AA. AA will reverse that effect and start the disciplinary proceedings against liquidator and RP for not reacting to this properly. Next, if that undervalued transactions are entered by the company with a view to defraud any creditors or a claimant, then they will restore the property or position and take back that particular asset and save the victims. Next, extortionate credit transaction. This is reverse. Here we are taking credit on unreasonable terms. Means my relative is there. From the relative, I will take loan. Generally, open market interest is 13%, 14% like that. I will give him 35%. Extortionate credit transaction. Or loan taken is 5 crores. Asset value which is kept as security will be 50 crore. Like that if you make extortionate credit transaction. Okay, these are called as exorbitant payments. Previously 2 years before, if you have taken any loan like that, those extreme terms of conditions, whatever you have agreed, will be made void. So avoid such a transaction which requires exorbitant payments. That's all. This is all about miscellaneous transactions in the liquidation area. Next one, this one, secured creditor in liquidation proceeding and distribution of assets. Okay, secured creditor in liquidation proceedings. What is this? I already told you this point. Secured creditors can be of 2 types. Secured creditor who tells that already one asset is kept as security to sell that asset and give back money. you have taken a loan of you have given a loan of 100 crore. Asset at the time when the asset is kept as security, it is 120 crore. Today the asset which is kept as security is only having 70 crore. I will sell that 70 crore asset, I will get the money, I will pay you 70 crore. Sometimes they will have two options. Option number 2, first let us see. Realize security interest. Sell that asset and give me. Sir, you have given 120. If you sell, only 70 will come. No problem, give that 70. Go by option 2. No, sir, I will go by option 1. What is option 1? Oh, 70 crores I will get. Do one thing. Sell this asset. Sell all the other assets of the company also. Maybe those assets make you higher value. In total, assets are heavy. Okay, then you pay me as an unsecured creditor. I will relinquish my security interest. Okay, and receive proceeds under section 53. You can go by any, but on a thorough research only they will take any of these two options. So whenever you realize the security interest, inform liquidator and identify the assets subjected to security interest. Any asset you will not sell. Really, which security is kept as a security interest to you? Order liquidator, please sell that asset and give my money. Liquidator shall verify such security interest and permit to realize only such security interest, the existence of which may be proved by the records of IU. Okay, next. Whenever assets are sold, money will come. From that, what is the sequence of payment? First one, we will pay insolvency process cost and liquidation cost. Workmen dues are there, PF, gratuity, their salaries, their wages, etc. 24 months prior to the liquidation commencement date, first make their payments. After the debts owed to the secured creditor. Which kind of secured creditor we will pay the debts? We will pay debts owed by the secured creditor who lost their security interest. That means they said that asset is kept as security. I don't want that. Mix it with all the other assets and pay me in an order. First preference give to them because of their great sacrifice they have done. Okay. Next, wages to the employees. This is workmen, this is employees. 12 months before we have to take. Later, unsecured creditors. Okay. Next one, central government, state government, statutory dues. Okay. Next, debts owed to the secured creditor for any amount unpaid after enforcing the security interest. Means what? Here, step number 2. Debts owed to the secured creditor means what? Debts owed to the secured creditor relinquished security interest. They said that, sir, how much loan you have given? 100 crore. Asset kept as security is 120 crore. Okay, sir, asset today value is 90 crores. Shall I redeem? No. You do one thing. Let that asset be used by all the creditors. Mix it. I will be taking in a sequence. Okay, they said that I will be taking in a proportionate basis. Don't sell that asset. They sacrificed their security. Mix it with others. Let other creditors also eat the money. So resolution process cost, first one. Liquidation cost, second one. Workmen dues are the third one. Debts to the secured creditor who relinquished the security interest is the next one. Next one is the wages to the unpaid salaries to the employees 12 months preceding. Next, very important, financial debts to the unsecured creditor. And next one, government dues. And next one is very, very important point. What is this? Sir, in this, secured creditors who didn't relinquish security interest, they really ask the company, sell the security interest and give my money back. Then where they are covered, they will not be covered here because they are not paid in a sequence. They are given money by selling the asset. Now listen carefully. I am a secured creditor. 100 crore loan I have given. Asset kept as a security. That is having only 80 crore value. They sold that asset, 80 crore they have given. Balance how much is there? 20 crore. In that balance, proportionately some amount will be paid. That's called as a debt owed to the secured creditor for any amount unpaid after enforcing security interest. Any remaining debts and dues, then I will pay to the preference. Lastly, I will pay to the equity. Very, 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 very important question. Easy point, but do 1 or 2 illustrations that were there in the past examination questions. You do those, you will get some confidence. So this is all about the process regarding liquidation under insolvency and bankruptcy code. Okay, so this particular lecture is completed. With this, we have completed the liquidation procedures under the insolvency and bankruptcy code. This is the area which can be tested in the examination. Okay, thank you.